Please be seated. We'll hear argument in 21-496, Houston Area Safety Council versus Mendez.
Court. Mr. Hollis and Mr. Knudsen will present argument for the petitioners. Petitioners have reserved 4 minutes for rebuttal. Mr. Hollis will open with the first 8 minutes. Mr. Knudsen will present the rebuttal.
Mr. Chief Justice, members of the court, thank you for the opportunity to be here today. I am Charles Hollis with the Coleman firm in New Orleans, Louisiana, and I represent Psychomedics. I know you all have read the briefs, but I just want to get the party straight. Psychomedics is the hair drug testing laboratory that conducted this testing on the sample provided by Mr. Mendez. And I also want to make sure that we're all on the same page on the Sandoval case. The Sandoval decision is a case out of the First Circuit where the Mendez case arose. And that case involved drug testing under DOT regulations. DOT regulations do not cover hair testing. And they also don't cover a lot of urine testing. They only cover a certain portion of urine testing. Now, the important thing about the Sandoval case is Sandoval held that a third-party drug testing administrator, in this case DISA was the defendant in that case, had no duty of care to someone who had provided a urine sample for testing where the testing was done under DOT regulations.
In Sandoval, the third party was performing administrative tasks and reporting tasks.
Yes, Your Honor.
But did not collect the specimen or test it.
Exactly.
Do those distinctions matter here?
No, I don't think so.
Why not?
Because they are, as the court in Sandoval said, they are really in the same position as the testing entity, like my client, Psychomedics, or the collecting entity. They have the same relationship or lack thereof with the donor. And so the Sandoval court, I think, correctly found that DISA sat in the same place as a drug testing laboratory.
While there may not be a contract between those parties, certainly that party's been harmed by an incorrect drug result. And so what would that person, the employees, what would they do in this situation? Just be harmed with no possibility of any way to be compensated?
They would not have a cause of action against the drug testing laboratory or against DISA.
Who would they have a cause of action against?
They would not have a cause of action.
Period.
Right.
So they wouldn't have access to the courts to deal with the harm.
Right. And that's really what the courts have done here, is decided through a balancing test to not always provide a cause of action for every potential wrong. And that's really what this balancing test is all about. And
But the reason we do that is the balancing test, when we decide not to recognize the cause of action, at least under the duty element of a negligence claim, is because of the balancing of the policy issues and whether the risk and extent of harm to an individual outweighs the harm to other policy concerns if we do recognize that.
That's right.
And what we've done is said, in the one case we decided was involving the employer, was, well, but we have all these DOT regulations that provide adequate remedies and redress for the individual, and therefore the concern on this side of the balance of the scale is not that great to outweigh these other concerns. But here we don't have that. So why doesn't that become a key factor in our analysis here?
Well, we don't have DOT testing here, that's correct. But we do have a myriad of other kinds of controls and oversight that are provided when we have hair testing. And we feel that those provide the same protections, which were key in the case that you're addressing, the Supreme Court case that you're addressing.
But you don't have to provide those. You just do that as a matter of grace?
No, sir. We can't operate, Psychomedics can't operate without licensure. Texas provides a license. We have the Food and Drug Administration has provided coverage of and approval of the very tests that were used in this case. The College of
There's not a
American...
question about the test, it's the question about how it was administered in this particular
I'm
case.
sorry?
It's not a question about the test itself, it's a question about how it was administered, right?
Right, and the College of American Pathologists, the state of Texas, and numerous states all provide certification and licensure for the testing.
And can that licensure, can a license be revoked? If I'm not suggesting that this case would support it, but in theory, if there were complaints, if people said, look, there are too many false positives, can the state, can the federal government revoke a license based on that? Is there a mechanism for that?
And these entities, among them the College of American Pathologists, the state of New York, do double-blind testing. They submit samples with known quantities of cocaine or marijuana, and they know when those samples went in. They know what
That happens in Texas as well?
I'm sorry?
That happens in Texas as well?
Yes,
Yeah.
yes, it happens because the samples are collected here and all over the United States, but they're tested in California.
Nice.
And so that's where the lab is located.
So that's the protection for the public. However, individual persons wouldn't be protected or have any recourse. Having said that, isn't it true that those same regulations would protect you all as long as you're complying with them? But, you know, still that doesn't really do away with the need for perhaps, if you're not, cause of action because of what it said a moment ago, right?
Well, if I understand what you're saying is, yes, there is that balance that Justice was talking about earlier, where a decision is made on these cases based upon a number of factors, one of which is the very low risk of false positives. You know, we've got oversight within the testing system itself in the form of an MRO, medical review officer. It's a medical doctor who reviews all test results, be it a urine test under DOT or not, or a hair test.
What if you have a false negative, say, for example, with a airline pilot, and it causes damage to a whole lot of people?
Right. Well, the testing is extremely reliable, but to provide protection for everybody, there is a cutoff that's set up at a level that's high enough so that inadvertent exposure to any of these drugs will not cause a positive test.
So your answer would be the same with a false negative, which could result in hundreds and thousands of people being harmed, as opposed to a false positive?
The testing itself is, as I said, extremely reliable. It can detect drugs down to the billionth of a gram.
And so in that one time when it's not, though, and there's a plane crash and thousands of people are killed?
It wouldn't be due to the person being under the influence of any of these drugs, because the amount is so low so as not to be something that could influence somebody's cognitive functioning. But it's high enough so that it couldn't be by mistake. In other words, it couldn't be some transient exposure to an illicit substance. I'm sorry.
As we're thinking about the burden, do you know, does the record tell us the rate of false positives? And does it shed light on what the burden would be to reduce the rate of false positives? Is that even feasible?
There are no false positives with hair testing. My clients never had a false positive.
In this very case, I mean, wouldn't you describe this as a false positive?
There was not a false positive.
How would you
I can
describe what
explain to you
happened?
what happened here. The individual was tested, and then with a screening test, which is the first test. It's called an immunoassay test. That test was administered, and it was what's called initially positive. So that was positive for cocaine. They collect another hair sample, taking what they call an aliquot from the sample that had been submitted by this gentleman for testing, and then they run that through a more specific and more exacting science using what's called GCMS. You've seen that or heard about it if you watch any crime shows on TV. And what that does is that is a system where the sample is bombarded in a machine that splits the.
So I think the process of controls is pretty well laid out in the brief and seems, on my reading, pretty rigorous. What I'm trying to get at is if you were going to impose stricter or more controls, how do we know what the burden would be to your client? How would it achieve that? What more could it do?
What more could my client do?
Yeah.
Nothing more. It's state of the art. And what I was saying to you is that there was a later test sample collected from Mr. Mendez. It was collected from another area of his body, which that hair grows at a different rate than the hair on your head. And so that affects the impact about how much drug is laid down in the sample. If you think sediment in the ocean, that's the way drugs are laid down in the hair sample. Plus, that sample was never subjected to the second test. It was negative to begin with, and so it was never subjected to the GC mass spec, state-of-the-art technology, which is going to find the drugs if they're there.
So the original urinalysis was a false negative?
Didn't
he?
Yes.
He did a urine sample and a hair sample.
Right.
Urine was negative, hair was positive.
And the urine sample, the thing about a urine sample is this. When you provide a urine sample, the sample gives a snapshot of about 72 hours for cocaine. So if you use cocaine on a Thursday and you provide a urine sample on Monday, you're going to have a clean sample because it metabolizes very quickly in the body. And all of the metabolites from that cocaine are excreted from the body within 72 hours. Hair testing doesn't work that way. Once it's laid down in your hair, it's there. The problem with hair testing, its weakness, if you will, is that the testing the hair has to have enough cocaine in it over a period of time, again, like sediment. And so a casual user of cocaine uses it on Sunday night, gets a hair test on Monday morning. In the first place, the hair hasn't grown out yet. And when it does grow out, it will not detect cocaine in a hair sample if there's only one or two uses. There has to be recreational use. So each testing mode has its own benefits and its own weaknesses.
It kind of sounds like you're arguing it doesn't matter how we rule here because even if we find that you have a duty, you'll never breach the duty.
You'll never breach.
You'll never breach the duty because you have state-of-the-art and everything works perfectly.
Well, Your Honor, I don't mean to be flippant about it, but that is true. They don't have false positives.
That's really what I was getting at earlier with my
They
earlier
don't have
question. That
false
seems to be what you're
positives.
saying. So what does it matter to your company if there's a duty because you're never going to breach it?
We never breach it, but doesn't mean we don't get sued. And that's part of why this is, we talk about use of resources and balancing tests and so forth. Simply because their product is perfect doesn't mean they don't get sued.
Is the federal government or these agencies that are doing these blind tests, do they have a zero tolerance? Like they find one false negative, false positive, whatever, like you're out, you've lost your license because it's supposed to be perfect, or do they have a tolerance level?
Judge, that's my understanding, and it's never happened.
Never a single error detected
Never
by them?
happened. They've done over 9 million tests. It's never happened.
Amazing.
Any other questions? Thank you, Mr. Hollis.
Thank you, Your Honor.
Mr. Knudsen, we'll hear from you.
May it please the court. I represent Houston Area Safety Council, which is a little bit different than Mr. Hollis's client. Houston Area Safety Council is a trade association, and they were responsible in this case for collecting the sample that was then sent to Psychmedics. However, the same case law referenced by Mr. Hollis during his argument and in briefs, we would say would apply to us, given the duty, the relationship. The relationship was with Turnaround Welding. We were hired by Turnaround Welding and not Mr. Mendez.
There's been emphasis on the relationship, and I wonder whether we wouldn't think about this similarly to the way we would look at defamation, where there doesn't have to be a relationship, but you undertake to say things about somebody and they can't be false. This feels like defamation to me because of the reputational injury and the obvious, the foreseeability of the harm of, improperly labeling somebody as a drug user.
Correct. Your Honor, I understand, and as of the way I understand Texas law, those are the only instances I have seen in which you can have a interference with at-will employment without a physical injury. It's either defamation or intentional infliction or tortious interference.
And so if you defame somebody and they lose their job as a result, they can get damages.
Right.
Even though normally you can't get damages for losing your at-will employment. So why wouldn't we look at this the way we look at defamation in that regard?
In that case, there's a higher standard. There's some level of intent required with defamation and tortious interference. You intend to disrupt the relationship, the at-will, whether it be defamation, that's through tortious interference, or just you intend to defame somebody. Here, the Court of Appeals has created a negligence action without a direct relationship, or where there's no evidence that my client created a situation that allowed for this to occur. And so what I had planned to address before the court were three arguments: analogous situations in which Texas has not imposed a duty which will be negatively impacted by the Court of Appeals decision, potential infringement on the at-will employment doctrine, and then, if time, the risk utility factors in Phillips. In Texas, on the analogous situations, it's long been established that when a doctor examines a person solely for pre-employment purposes or for workers' compensation or disability evaluations, the doctor's only duty is not to injure that person during the examination. It's reached by the Houston 14th Court of Appeals and Dallas. In that circumstance, the doctor doesn't owe the physician-patient relationship the duty that's associated with that. As the Dallas court held election versus Dill, a doctor's examination of a person solely for the benefit of a third party, such as to determine the person's fitness for employment or extent of disability, does not create a physician-patient relationship. Similarly here, HASC was not hired by Mr. Mendez to provide health care. He was hired by the employer to collect a sample to send it for testing. And so, similar to the physician cases for pre-employment screening, a duty should not be imposed against HASC. But if the intermediate court's decision is upheld, I believe that now that's going to open the door to not just testing agencies and collection agencies, it's going to be physicians who also provide this type of pre-employment screening. If an employee...
Backing up, zooming out on this, when is some sort of pre-existing contractual relationship required for a negligence action, and when is it not? How do we draw that line? Because, I mean, obviously, if somebody runs into my car, I don't have a contract with them, but they still have a duty of reasonable care.
Sure, correct, Your Honor. And in that situation, I think we move away from the special relationship to creating a dangerous situation. I think that's when the duty analysis comes up, and that's when, in our motions for summary judgment, we established that all levels of sterility were satisfied, and Mr. Mendez even testified that he didn't notice anything different. He thought it was his hair submitted.
But you're now responding to the duty question with a no breach argument, and the issue here is not whether you conclusively establish no breach. The question is whether there was a duty to begin with.
Correct, Your Honor, and I think...
Which is kind of what your co-counsel was doing. You know, we never make a mistake. Well, great, but do you owe a duty is the problem.
Correct. And so what I was more going to is the creating a dangerous situation, which I think you would at least have some of that evidence. As Justice was involved in a car accident with third person.
Right, so you're arguing here that the evidence conclusively establishes your client did not create a dangerous situation for Mr. Mendez. But the problem is, your client could, in some case, create a quote-unquote dangerous situation for such an employee if you were just haphazard and lazy in the way you did your job.
Understood, Your Honor.
No
but-
different than a driver who drives negligently.
And that kind of goes a little bit more to the Phillips factors and what we would weigh, and we would contend outweighs the risk or the foreseeability would be the magnitude of the burden imposed on a company like HASC. If we get notice that there has been an employee claims a false positive has occurred, and we're sued, and all of our, as in this evidence, there's no evidence of where, A, whether there was a false positive, B, where that supposedly tortious conduct came up. Was it with HSE? Was it psychmedics?
Well, I think the allegation is that there's negligence in connection with collecting the sample with respect to HASC.
Correct, Your Honor.
And in that sense, you have direct interaction with the plaintiff.
Correct, Your Honor.
And so if you were collecting the sample and you were doing it as part of a lab and it was being submitted as a part of a routine physical, you would have a duty to that patient, right? And so you're asking to distinguish between the duty owed in connection with two samples that you treat exactly the same way.
The only difference between us and a patient coming in for lab work is there's not that relationship. We were hired solely by the employer to collect the sample to send off for screening. It wasn't for health care or to provide any information to Mr. Mendez. And I think that's a little bit of...
So let's say it's somebody for whom it's a direct relationship. Well, let's not say that. Let's say somehow you come to believe that somebody is using drugs, and you're not hired as a testing company or anything like that. You're just a third party. You go to an employer and you say that person is using drugs. That turns out not to be true, and they lose their job because you said that. Is that actionable defamation?
I believe if you have the knowledge that makes it actionable, that is required for defamation.
Well, what's the
action.
you don't have to have knowledge of the falsity, do you? If you're negligent as to whether it's true or not. If we're talking about a private figure.
Correct, Your Honor. So in that circumstance, I think that would be actionable in that situation.
Do you have the same sort of regulatory oversight that your colleague was describing with federal and state people doing these blind tests of your aspect of this?
No, for the collection, I mean, I believe our employees receive certifications by the state to do that, but it's not the level described by Mr. Hollis.
What would be the equivalent protection for people in respondent's position vis-a-vis HASC?
I think it would be the licensure of the employees that they are able
The
to
individual
maintain.
employees.
Yes.
Is there the ability for HASC itself to lose its license or credentialing if there were false positives of a certain degree that were marked or not?
And I don't know the answer to that. I don't know if HASC has its own independent license, separate and apart from those of its employees.
If HASC were to have multiple false positives, is it just a matter of, well, hopefully people will start realizing that it's not doing its job well and so they'll find competitors, or is there anything more formal that you know of that would provide any redress or oversight?
I'm not aware of any, Your Honor.
Is a false positive on a drug test the kind of thing that has to be reported in the future and that follows somebody beyond the immediate consequence of losing the job?
I'm not aware of, as in nurses, I don't know that you're ever going to know, say that they have a complaint against their license. I don't know that anybody's going to know specifically. The public at large is going to know the basis for it. They just may know that they lost their license or they had a complaint against the license. And that's kind of in regard to the at-will employment. Oh, I see I'm out of time here.
Well, if I might just ask one last question, maybe guess that. Suppose that it was the employer who directly did this, wasn't contracting with either you or psychedelics, but in-house had their own people to collect, their own scientists to process it, and the same thing happened. Would the employee have any claim against the employer for that at all?
No, Your Honor. I think that would be under Mission Petroleum versus Solomon, which came out of the Houston First Court, said we're now getting into at-will employment issues, and there is no recourse against the employer.
Any other questions? Thank you, Mr. Knudsen. We'll hear from the respondent.
Thank you, Your Honors. Robert Goodman for Mr. Mendez. Before I begin my argument in chief, I want to respond to some of the points that have been made by opposing counsel. Excessive belief in one's own goodness breeds objectionable hypocrisy on occasion. Psychomedics is subject to a duty regime in multiple other states. It's trying to ask this court for an exception in Texas to the duty of professionals to act professionally and be responsible to those whose lives they can affect. So there's that. The notion that they never do anything wrong is ridiculous, or they would not be the subject of scrutiny by the federal government in the first place, or any state law which has imposed a duty.
Was there a demonstrable record of them falling down on it as a result of that scrutiny?
Well, they have been sued in a number of other cases, one of which was quoted by the Court of Appeals.
It's easy to sue, but I mean, have they been found to have actually had a lot of botching? I'm wondering if that level of scrutiny might be an attempt to make sure that they don't have these errors that your friend on the other side. I mean, it's an extraordinary statement that is perfect.
It is extraordinary, and it's not believable. And
is there any evidence that he's wrong?
Excuse me?
Is there any evidence that he is wrong? I mean, do we have results of litigation or the federal government or state governments or anybody else saying, well, here it is, here's your false positive?
Your Honor, I don't know the answer to
You
that,
haven't
but
found
I
a single
will.
instance of them having a false positive anywhere?
False positives do exist, and I will say that before the issue was resolved in the trial court on the issue of duty, I had conversations with toxicologists who had a very good idea of what went wrong here. But that's the breach issue, not the duty issue.
So please go ahead. If the employer did the testing in-house, just hired people to do it, and they mishandled it, and the employer makes a mistake and fires somebody as a result, do you have a cause of action against the employer?
No, the employer is not a professional, either in terms of collection, making sure of sterility, and
Well, the employer undertakes to bring in an entirely new department to do drug testing, and they submit to the same regulations as everybody else, but this is an in-house arm of the employer itself that's doing it, and that causes the problem and leads to the firing. Can you sue the employer?
I think that's been decided, although Sandoval itself, in the DOT context, expressed reservations about whether there should be an exception for DOT mandated.
And so the question is, if it's clear to everybody that you can't sue the employer who brings the testing in-house, then wouldn't it be a strange result if you can sue the agent that the employer brings in just contractually, not fully in-house, but hires a third-party agent to do the work, and now you do have a cause of action?
It would not be strange at all, Your Honor. It would be completely consistent with the duty of plumbers, electricians, doctors, lawyers, other medical professionals as professionals to uphold professional standards. The second bit of hypocrisy on the part of psychomedics is saying we do everything with a high degree of expertise and then not standing up for that expertise by assuming the duty to use the expertise knowingly and prudently.
But all of that, the professionalism and the undertaking, is true if the employer does it in-house. And the law seems to disfavor an action to essentially get your job back. And I'm wondering why this would, you would suddenly spring, an action to get your compensated for losing your job springs into existence because of the nature of the relationship between the employer and the drug testing company. It doesn't make a lot of sense to me.
Your Honor, with respect, it makes perfect sense in the sense that because drug testing professionals are professionals, profess to have expertise that an employer does not profess to have in the subject matter.
Well, the reason we said there was no duty in Sandoval was because where the employer was doing the testing in-house was that the DOT regulations applied, and we said that adequately balances the interest. But there's no comparable regulations that apply here, right?
There are none, and in Sandoval, the court expressed reservations about the holding it was making in the,
I'm sorry.
as
Yeah,
well, and
emission
said,
controls.
you know, we are.
The employer wasn't the defendant in Sandoval. The employer did do the testing in-house in Sandoval. And was, so, but the second question is, if we were to recognize a duty, what is the scope of the duty in terms of to the employee? Because in SmithKline Beecham, the court said there's no duty to inform the test subject of the appropriate protocol for collection of the sample.
Well, that's.
So we know there's no duty there. So what if there's no duty there, what is the scope of the duty that you would say we should recognize?
You know, that's easy. I call SmithKline the poppy seed case, okay? That was a rare avis. But the duty is for the collection to be sterile, for there to be a chain of custody that is professionally handled. The duty of the analyst is to calibrate its machinery correctly.
But how are those duties different from a duty to inform a test subject, don't ingest poppy seeds before you give this sample because it could potentially result in a false positive?
Because they are central to the claimed expertise of psychomedics and the claimed expertise of HASC. Neither HASC nor psychomedics claim the expertise in the variety of reactions that can be shown on drug tests to different substances. They are central. They're like your duty as a lawyer to avoid encouraging fraudulent conduct on your client's part, or your duty to rely on the right rule or right rule of law in giving advice.
So it's a potentially commission, a duty to not negligently perform tasks as opposed to no duty to disclose or to inform.
Your Honor, boy howdy. It's a central duty of a professional to not engage affirmatively in negligent conduct. And not, the poppy seed example is a kind of a, would have been nice to volunteer that, but it would have been volunteering that. That's not part of the duty, the central duty of a professional to consider all possible iterations of a circumstance. But they do have a duty in the case of many medical professionals to conduct themselves in a sterile manner, to calibrate equipment correctly so that it doesn't falsely register a concentration of a substance that doesn't exist. And I do want to correct the record, and as one of you noted, the urine test that was negative on Mr. Mendez was contemporaneous with the supposed false positive on the hair test. And then he had another hair test a few days later with psychomedics that was a negative. And then he had his own test that was negative a few days after that.
In the briefing, I don't know if the record bears this out. In the briefing, it says that the hair tests were different because one involved chest hair, and the reason the chest hair was used was because there wasn't enough hair to collect on the top of his head, and that the follow-up testing involved samples from the top of his head. And just wondering about, is that correct? Is that a correct understanding
Your
of the
Honor,
record? And should that make a difference in terms of trying to evaluate what happened?
I think that is correct, but the contemporaneous urine test being negative, contrary to the representation made by Mr. Howell, is also critical. It means that psychomedics, his perfectionist client, is not always perfect.
Disagree with his 72-hour point about the cocaine or drugs in the...
Your Honor, I don't have that technical expertise, and I have had a number of cases, but none involving the contemporaneous negative urine test, none involving a test by the same analyst within days that supposedly is going to produce the same result, producing the opposite result.
I think we've, in our questions, maybe confused Sandoval with Solomon. It may be in y'all's answers too. I got a little confused. Solomon being the Mission Petroleum versus Solomon. But
Right.
but in Solomon, in Mission Petroleum, we held that the employer who handles the collection and transportation of the sample owes no duty to the employee. And as Justice Busby said, primarily we did so because DOT regulations imposed a strict regime on the employer and allowed the employee to have what we called redress during the process.
And
And
even
so
that.
my question on that is, the reason that was the case was because we were dealing there with an employer that was a trucking company subject to all those DOT regulations. Not all employers are subject to DOT regulations, and yet some may handle the collection of samples. In your view, does an employer who is not subject to DOT regulations or anything like them when it comes to collecting samples, would they owe a duty?
No, because they're not professionals, Your Honor, and I don't know that any employers continue to do that, because employers do not want to, either themselves or through contracting with a third party, create a situation where there is a risk of false positives so that they lose potentially valuable employees.
Why wouldn't an employer say, well, I don't want to have a risk of false positives, so I'm not going to contract this out with other people. I'm going to acquire these, HASC and psychedelics, essentially, bring them in-house. So they're under my roof. I'm absorbing them. They're part of my operation. Now they are professionals, and the theory is that because they owe their duty completely to me, I'm going to get the best quality responses. In that circumstance, they're professionals. It's the same exact human beings that are doing the testing. Same result or not?
Using that hypothetical, yes. If they're professionals who, like plumbers and electricians and lawyers and doctors, profess to have a special expertise, and that a misuse of that expertise can cause harm to an individual in the state of Texas, they ought to have a cause of action, certainly.
So that'd be new law, but it would be on the ground.
But it would be a new
that-
facts, yes. It would be a very unusual set of facts. But, and I do need to, Sandoval was the distinction, well, the distinction in Solomon was the DOT. Okay, you're correct. The distinction in Sandoval was the administrator, the TPA, the third-party administrator. So and as I've traced the very bastardized history of the law in this area in part of my brief, we do, and the Court of Appeals agreed with this. This is an issue of first impression. An employer who's not subject to DOT regulation, who contracts with professionals to provide their expertise, and there is always a possibility, notwithstanding what Mr. Howell says, of a stray from perfection, let us say, in any endeavor, human endeavor. And I want to make the point here, too, that you're not going to get cases here that are edgy or frivolous. People have to hire toxicologists. They have to, it's not a Chapter 74 cause of action, but you have to have an expert to say why the collection was improper, why the analysis was improper. The court is not going to encourage frivolous litigation, much less lack of, unmeritorious litigation by agreeing with at least 14 other states there is a cause of action. I think the question about defamation is particularly apt. There is a constitutional First Amendment question in this court and otherwise about what the standard is, but there are some cases not involving public figures, for example, where it is negligence.
But if the defamation is only telling the potential employer who has the employment at will doctrine, here's somebody with this degree and they don't have to hire them anyway, is that really the kind of defamation?
I don't think the at-will doctrine is relevant at all, because we're not dealing with decision makers about termination. Okay? There are lots of collateral consequences to any professional's negligence. Termination is one in the employment context. And honestly, where I disagree with the Court of Appeals is that the holding of the Court of Appeals need not be limited to the employment context, which it tried to do for some reason that is not really sustained by the briefing, because this comes up in the context of parental rights terminations, probationary revocations, and those are even more significant consequences than loss of a job, loss of freedom, loss of connection with a child for the rest of one's life. And so,
all of those are really significant consequences. I agree with you. It's a highly regulated area. We have federal, we have state, there's workplace safety, there are agencies, the legislature is concerned about this, Congress is concerned about this. It could affect almost anyone at any stage of life. Why does that not militate in favor of saying that if, with all of these complex balances between public safety and individual rights, if there's going to be a cause of action for it, it really ought to come from the legislature to define one and to decide what would qualify as over-deterrence, what would be the proper risk tolerance for us to have, as opposed to this court. We have the Court of Appeals, for example, describing why it's good business practices for your opponents on their side to do something. Well, is that really what courts are good at doing?
I think the answer was given by Oliver Wendell Holmes in the common law. I think the answer was given by the New York Court of Appeals in Fallsgraf. Courts are there, and this court has created causes of action. It's gotten rid of causes of action based on societal changes. But
we've done a lot more of one than the other of recent.
Excuse me?
We've done a lot more of getting rid of than creating in recent
Well, you would know better than me, but in any case...
Because there's a lot of water under the bridge since the late 19th century when Justice Holmes wrote the common law, or even since Justice Cardozo.
Well, Phillips and El Chico continue to be the guiding light for this court, and they should be. This court is a court that is an inheritor of a common law tradition, an English common law tradition, and it should not hesitate to exercise its power of common law jurisprudence by creating duties where the social utility of not having a duty is actually negative. You would be exalting inexactitude by not creating a duty here. You would be rewarding people who claim to be professionals and who actually are subject to duty regimes in other states and saying, well, in Texas, you get away with being wrong. In other states, you don't. And that's not something that we should be proud of doing. The notion that one of you seized on, where there's a wrong, there's a remedy. The notion that Mr. Hollis preaches that he's very comfortable with there being no cause of action in representing a company who is facing such causes of action in multiple other states for the same reasons that we've argued through the courts here is correct under Phillips, is not sensible. If you're a professional, there's a Latin phrase, cum on air. If you want the benefits of being professional, you have to take the burdens of being professional. And that's what we're dealing with here. This is a burden which they haven't faced, and they've only haven't faced it because of the crazy quilt nature of the development of the law since this court ruled in the poppy seed case and then was completely misinterpreted by Willis as having decided an issue it expressly reserved. And Willis made a decision, an eerie guess, they call it, that this court does not have to follow, that was clearly wrong, and this court should follow the Court of Appeals in saying so.
There was a statement earlier that the testing here took place in California. Is that right?
Excuse me?
There was a statement earlier that the testing occurred in California. Do you know if that's...
That was a representation of the court. I do not think that's in the record.
Okay, but assuming that's true, is there a cause of action under California law that your client could pursue here in California?
Your Honor, I have, the answer is I don't know. I've often pursued the question. I do a lot of employee representation. If someone is working for a California company, can they sue on a public policy wrongful termination claim? I think my general answer has been no. It's kind of, locus, I forget the Latin phrase, but, where the act occurs is generally the source of the governing law.
Here, the act may have occurred in California if the testing was wrong there, so that's why I asked.
Well, the results, and then, there's also conflict of laws considerations relate to where the results occur. So I don't think that's an answer to the problem because obviously that's a representation which may or may not be true today, or even if it was true yesterday, they may establish other places, but it should not depend on that. And so I think that...
Employees take lots of kinds of tests in association with applying for employment, like a typing test, a word processing test, psychological testing, all kinds of testing. Are you advocating that an employee could sue any of these testing administrators in connection with not getting a job, or is there something different about drug testing and we should treat it differently than other kinds of tests that are administered in the course of evaluating someone for employment?
Well, the severity of the potential consequences, which has been pointed out not only in the Texas cases by the court in Sandoval, but in other courts, that's one distinction. Okay, and again, this applies to parole revocations, family rights termination. The severity of the consequences would be the main issue, but the professed expertise that has been demonstrated here also distinguishes this from the variety of the tests that you've elaborated upon. And
Sorry,
so,
very quick, if I
Justice
may.
Boyd.
You're out of time, but I did just want to get
Sure.
one last question in. Could you summarize for us your response to the petitioner's reliance on the Court of Appeals decision saying that a doctor has no duty to a prospective employee, that the doctor is hired by the employer to test for fitness?
I will, Your Honor, and I took note of that. That doctor is, interestingly, as he admitted, that doctor is not allowed to do harm, okay? What we're talking about here is collecting and analyzing entities doing harm, number
Well,
one.
but a doctor could do harm to an individual by saying, yeah, he's not in good enough shape for this job, and then cause him to lose the job, and that's the same kind of harm you're talking about. What he says these cases say is that the doctor can't, cut them open and injure them in the same way that they wouldn't be able to physically harm. You're not alleging that kind of physical harm. You're alleging employment harm, occupational harm.
It can be loss of parental rights harm. It can be parole revocation harm. They're taking tissues. Okay, they're doing things which these examining doctors don't do. They're taking tissues and they're telling you, to use a dramatic example, you have cancer. You don't have cancer. You have cocaine. You don't have cocaine. I haven't used it in 25 years, and I've taken all these, and you took your own contemporaneous urine test and it didn't show up. And 2 days later, you took another hair test and it didn't show up. So I do think it's distinguishable, and I don't think this court ought to shy away from doing what the Court of Appeals did and what Willis, as your honors know, was going to do in the first place before some majority of that, well, I forget whether it was a appeals or district court, before that court reversed itself. This is a duty that is as consistent with the plumber's duty, an electrician's duty, a lawyer's duty, a doctor's duty, and it should finally come about in Texas.
Any other questions? Thank you, Mr. Goodman.
Thank you very much.
Mr. Knudsen, you have 4 minutes.
Thank you, Your Honor. During the respondent's time before the court, they mentioned professionals repeatedly. And in our reply brief, we pointed out that the courts actually apply greater scrutiny when we're dealing with a professional. Attorneys, there has to be an attorney-client relationship in order for there to be a duty traveling between the two. Same with architects. And Vernoy Black out of Austin, some house guests filed suit against the architect of the house when a balcony fell down. And after doing a duty analysis under Phillips, the court found there is no relationship between the architect and these guests. And the burden of an architect going and ensuring that every single thing through the construction process was correct and met the designs was too heavy a burden. Doctors, there has to be a physician-patient relationship in order to be that broad duty. And so when we're talking about professionals, there's greater scrutiny on that relationship.
But professionals can defame somebody, and you wouldn't require a special relationship in that context, right?
Correct, Your Honor. And in regard to HASC, I would just point out that we didn't communicate anything with the employer. We collected the sample and sent it to psych medics, which then turned over the results to turnaround welding. And also, just to be clear, the record shows that Mr. Mendez was afforded several protections in this case. He had several retestings done. He went through a substance abuse program. DISA, the drug testing program administrator, recommended him to be returned to work.
But none of those things helped.
Correct, Your Honor, and that's a
The
little.
retests were negative. He went through the program, but he still couldn't get his job back or get new employment.
He was able, Your Honor, he was able to secure new employment quickly thereafter.
After two others said no or something, right?
Correct, Your Honor.
Yeah.
And that presents a problem here because Mr. Mendez also filed suit against his employer for disability discrimination. So that leaves a question as what was the real reason for Mr. Mendez's termination? Sure, there's a contemporaneous connection, but we don't know much else. And so what's going to happen is if we go back down, we're going to have to conduct discovery against the employer. We're going to have to request documents. We're going to have to take depositions, which then impedes the at-will employment decision process, right? The freedom to disrupt, or the freedom to let somebody go for any reason, they're now going to be subject, even as a third party, to.
Y'all raised that argument in your briefs that this brings up the at-will employment issue, even though y'all are not the employer. But to me, I'm having a hard time distinguishing that from just any PI case. I mean, if I'm in a car wreck and my leg is injured badly, and my employer says, you're no longer capable of doing the labor you've been doing for me, I'm going to have to let you go. Don't the plaintiff and the defendant in that case have to do the same kind of discovery and deal with the same kind of evidentiary proof when I seek loss of future wages?
Ideally, Your Honor, I mean, we don't see it very often because there's such a definitive, the employer was working the accident and then they quit working. This case presents a little bit of a different paradigm in that there was a subsequent lawsuit against that employer for another reason, and he continued to work for he hired by a second employer.
If the employer is bereft of a skilled, valuable employee because of a negligently processed drug test, can the employer bring an action against you with the contractual relationship that you have with him?
I guess the question would be, I think there is that direct relationship between us and the employer, and then the question would be, what were the damages? What was the causal?
But in theory, that duty exists, and that damages. You cost me my single best, pipe layer or whatever. It cost me this. I lost my lease expired for want of a pipe fitter or whatever. Then you'd be liable potentially for that.
There would be a duty in that circumstance.
If if one of your people had it out for Mr. Mendez or somebody else, let's say, and they surreptitiously swipped the sample to be something where it's going to show, they have a loathsome disease, something that's definitely defamatory, would that be defamation potentially, even though there would be no direct communication between you and the employer? You would know at that point what would be communicated as something that is highly defamatory.
I'm not sure that the HASC as the entity would be responsible for that.
Just the individual?
The individual for that. I see my time is up. Thank you.
Any other questions? Thank you, counsel. The case is submitted. The court will take another brief recess.
All rise.